Hello, welcome. This is the second part of our series on hurricane coverage. Today, I'm very happy to have Kelly Johnson with me from our Southeast office to talk about this topic titled When Multiple Perils Combine, Hurricane Coverage and Concurrent Causation Issues. This is a fascinating topic. We've written quite a bit about this at SDV. There's more material actually on our website that you can reference. But before we get started, let me introduce myself and introduce Kelly. Kelly, why don't we start with you? Why don't you introduce yourself for us?
Hello, thank you for joining us. My name is Kelly Johnson. I am an attorney with Saxe, Doernberger, and Vita, working in the Southeast office. I am a commercial litigator, been practicing for about 13 years, and my focus has been entirely on policyholder coverage work since I joined Saxe, Doernberger, and Vita.
And I'm Tracy Sax. I've been practicing, 37 years now as a commercial litigator. And since the late 80s, I've focused exclusively on policyholder work on insurance coverage. And for today's topic reference, I would say that more than ever, we are doing a lot of first-party work that is, in other words, damage to people's own property about natural disaster damages. In fact, Kelly is the senior associate for our natural disaster recovery group that is nationwide. We are in office national coverage practice with, as Kelly mentioned, she's in the Southeast, I'm up in the Northeast, and we have an office on the West Coast as well. And we do this work everywhere, but this is a growing part of the practice of natural disasters, and we're in hurricane season, so we thought it was appropriate to roll into this topic and do this series. So just to get us oriented, as policyholder lawyers, we're always talking about risk transfer of some sort, and I like to start with some sort of insurance geography to figure out where we are in the world. And so you'll see on the left-hand side of the screen, the types of things that involve third-party liability insurance. And by that, we mean that this is when someone else makes a claim against you when they've had either bodily injury or property damage to their property or their selves. On the right-hand side of the screen is first party, when the person who bought the policy, it's damage to their own property. Now, on a bodily injury side, you'd have health insurance here too, not something we focus on, and certainly not today. But today's focus is going to be on this side of the ledger, on the right side, where we're talking about damage to people's own property and how they get insurance coverage for that. So Kelly, why don't you talk about what we're going to talk about today a little bit here?
Thank you, Tracy. So today we are going to focus on the three types of first-party policies that typically provide coverage for hurricane-related losses. And those are commercial property policies, builder's risk policies, and homeowners policies. We have a cartoon here, which sort of illustrates when it is these policies would come into play. And Mr. Finkelman is learning the difficulties of getting his coverage. It says, let's see here. Here it is. Your policy does not cover floods, earthquakes, or acts of God. Sorry about that. So
there aren't that many things funny about insurance, so this is helpful.
So these are the types of things we're going to be dealing with today. And these first-party policies, they essentially cover your own property, whether that be your business property under a commercial property policy, property that is under construction under a builder's risk policy, or your home under your homeowner's policy.
So Kelly, why don't you just let's just stay with this for a moment and dig in a little deeper. Are there commonly with these types of policies certain things that you'd have to show in order to get coverage as a policyholder?
Yes. To get coverage, you need to show physical loss to covered property. And there's really three key elements here, all of which need to be met. You need to show loss from direct physical loss. You need to show that loss was to covered property, and that loss was caused by a covered cause of loss.
So that's the general intro, what would be in the insuring agreement, right? And so when we've got a hurricane, let's say I'm a policyholder, hurricane happens and I get damage to my property. What types of things are going to be typically covered under these policies when you have a hurricane?
Well, when we're dealing with hurricanes, causes that are typically covered would be things like rain, wind, or wind-driven rain. But there are also exclusions that could possibly negate coverage. And in a hurricane scenario, some of the more common exclusions are flood and faulty design, materials, and workmanship, essentially construction defects. So those causes are usually excluded under all three of these first-party policies and would basically take away any coverage that was caused.
So I don't really understand then. So I own a commercial piece of property, and the hurricane comes in, and it gets wet. You're telling me if it's caused by flood, I'm not going to have coverage?
Well, it depends. How did it get wet? Did it get wet because wind-driven rain came in the window? Did it get wet because water was rising? And those are the issues you need to think about when you are preparing a claim resulting from a hurricane. So yes, water damage is usually covered, but we need to drill down on exactly what caused that water damage to determine if coverage is available.
Okay, so I mean, just sticking to basics. So some types of water damage are going to be covered, but flood would not. And flood would be when the water comes up from below, it's a flood. And if the water comes from above, then you probably have coverage as rain and wind-driven rain. Is that a fair statement?
Yes, typically that's how it would work.
So you mentioned faulty design, materials, and workmanship. I don't understand, how does that fit in to a situation with a hurricane? I didn't design the hurricane. What are we talking about here?
Well, a common scenario, and that's actually what we're here to discuss today, is when something like rain or wind-driven rain combines with something like, say, an improperly installed window. The improperly installed window allowed that water to come in, but on its own, the improperly installed window didn't cause any water damage, and on its own, the rain didn't cause any damage because it wouldn't have come in if it wasn't for the defective window. So that's where the faulty design, materials, and workmanship come into play, is that a lot of times something that's improperly built will combine with the weather event in a hurricane to cause the damage. And the question becomes, is it covered?
Okay, so now we're getting to today's topic, this idea of concurrent causation. And so you could have multiple things combining together that cause damage to my property, some of which might be covered and some which might not, and they might combine in different ways. Is that right?
That's right. That's right. And there's essentially two types of concurrent loss that may occur. The first is what we call sequential loss, which is like a chain of event, a series of two or more dependent related events, like a chain reaction. And the second is what we refer to as non-sequential, which is a series of two or more independent, unrelated events that overlap. So two unrelated events that happen simultaneously to cause the damage.
Let me see if I can move to the slide. I was having a little trouble here. I think you've got a slide here. Okay, so you mentioned, so go through that again. So we've now got the slide up with about concurrent causation and sequential loss. So describe that again. The sequential loss is what?
So a sequential loss is the first type of concurrent causation that may occur. And under a sequential loss scenario, it's a chain of dependent causes that ultimately causes the damage. So it's a chain of event type situation. And the example that we provided you here is that, say there's a fire. The fire then triggers the sprinklers to go off. The sprinklers then cause water damage in the interior. Water damage then causes the mold. The mold then causes the damage to the sheetrock. There's a sequence of causes here, all of which end up resulting in the damage.
All right, so but I think based on what you said earlier, the important part is that some of these things are covered by the policy and some are excluded by the policy. So if we took, for example, let's say that the sprinkler water and the water damage would be covered, but it has an exclusion for mold, we've got this problem that both of them together have caused damage to the sheetrock. Am I getting this right?
Correct. That's the problem with concurrent causation. The question mark becomes, is the damaged sheetrock covered? All of these events combine to cause the loss. Some are covered and some are not. And that's where we get into the different jurisdictional approaches to the legal theories on this.
And this may or may not match people's policy, and everybody's got to read their policies to see what's covered and excluded. But to keep this even simpler, if it turned out that the fire is covered, but maybe the damage to sheetrock is solely due to the mold, but mold isn't covered, the question is the fire the cause of the damage to the sheetrock, or is the mold the cause of the damage to the sheetrock? And in this case, in some respects, it's both. But for the fire, the sprinkler wouldn't have gone off. And if the sprinkler wouldn't have gone off, the sheetrock wouldn't have gotten wet. And if it hadn't gotten wet, it wouldn't get moldy. So that the insurance company could certainly argue, well, we don't pay for that. That we're replacing the damage to the sheetrock because it's moldy. But the policyholders can say, but no, I have coverage for fire. This is a direct result of the fire itself, and therefore it should be covered. And so what does a court do with those type of things?
Well, there's the typical approach by most jurisdictions is to follow what's called the efficient proximate cause doctrine. And under that doctrine, basically the courts look to what is the most significant or the dominant cause in the series of events. If that dominant cause is covered by the policy, then there will be coverage for the loss. But there's a couple of different approaches. The courts don't uniformly define efficient proximate cause. So some courts will look at the series of events and focus on the initial event in which caused the others to occur.
Well, that's good for us, right? In this case, the fire in my example, at least under my hypothetical policy, the fire is covered. So if the court's going to focus on the first event, I'm going to have coverage for everything, right?
Yes, if you have coverage for fire. But if you don't have coverage for fire and you do for water damage, under that first approach, you probably would not have coverage. But then some jurisdictions actually focus on the last event in the chain of events. So under this example, it would be the mold. So you would look to see if you have mold coverage. If mold is covered under your policy in those jurisdictions, you would have coverage for the damage. If not, it would be excluded.
So we talk about this in a lot of our programs that, and one of the reasons we have a national practice is because the damage might be determined to be covered or uncovered based on state law, and state law is different from state to state. And which state's law applies to your policy is going to make a big difference. If it turns up you're a property owner with property all around the world and all around the country, and you've got a single policy, even though the damage may occur to a particular building in Florida, it might be that that policy gets interpreted under law other than Florida, depending on those state rules. So to some extent, what you're pointing to is the fact that the outcome on these, whether you have coverage or not, depends specifically on the state law that applies. So as you say, if it's the first one, we might have coverage. The last one, we might not have coverage. Or if it's something in between, we may have trouble. Are there other rules out there besides the kind of this first and last rule?
Yes, there is sort of a hybrid of the two, in which courts will hold that it's not necessarily the first, it's not necessarily the last, but they'll know it when they see it. And we usually call this the predominant cause rule or the Appelman's rule. So under that approach, using our example, the court would look to see which one of these causes really was the predominant cause of the damage. Was it the water damage that required the sheetrock to be replaced? Or was it more mold that required it to be replaced? Or was it fire because everything was burnt first? And depending on which of those causes is or is not covered, the damage may or may not be covered.
That's interesting. So this seems like something that isn't just purely a matter of reading the policy, but is when you get to this, whatever this dominant cause is, the know it when I see it type of rule, it really may come down to an issue of fact, which gets decided potentially by a jury.
Yes, it is an issue of fact, and also the burden of proof lies on the insured. So as the policyholder coming to your insurance company seeking coverage, you need to be prepared to package your claim in a way which focuses on the cause being a covered cause of loss.
Okay, so let's go back to that burden of proof. That's really maybe something we should explore a little bit. You know, for all purposes, not just for hurricanes and concurrent causation issues, the initial burden of proof is always on the policyholder to show that they have something covered. So I show up and I say, I've got a fire. My policy covers fire. And at that point, since there should be coverage for that, I assume that for this example that you've put together, that the burden is going to be on the insurance company to prove that mold, if that's the reason why they don't want to pay, is actually the cause of the loss, and that burden falls to them to prove that. Is that accurate?
Yes, under the efficient proximate cause doctrine, the burden would initially be on the insured to show that the dominant cause was a covered cause of loss. then it would shift to the insurance company to show that the dominant cause was actually an excluded cause of loss.
So as much as that's pretty complicated and has all these different potential rules, I actually think this is the simpler of the two types of concurrent causation to deal with. This one, we're actually choosing between alternate causes that are actually one covered and one uncovered, and we have rules to follow for that. Whereas let's talk about the other type, which if I can get this to move, the non-sequential one, where it's much more difficult to choose between the covered and the uncovered because they combine together at the same time to cause the damage. And maybe just go through the example you've got up here on the chart and explain how the non-sequential losses work by comparison to sequential.
Yes. The efficient proximate cause doctrine that we were just talking about is inherently problematic because there are non-sequential loss scenarios to which the doctrine is impossible to apply. For instance, when there's no particular event that is sufficient to cause the damage on its own. Previously, we spoke about a window being improperly installed and water coming in, wind-driven rain coming in. Wind-driven rain on its own, had the window been properly installed, would not have caused the damage, and the improperly installed window on its own wouldn't have caused the damage. So which one is the dominant cause? Another scenario where the efficient proximate cause doctrine is impossible to apply would be where the combined causes each separately are responsible for damage on their own, but it's impossible to isolate what damage is attributable to each. So
hold on, Kelly. Let me follow that because that's kind of confusing. So the first example is that each one, if I heard you right, each one on its own would not have caused damage. Only when they combine does it in fact cause damage. And so, but the second example is they each might have caused damage on their own, but it causes damage to the same thing and it's impossible to separate. Which is which? Is that what we're saying?
Correct. So the example that we have up on the slide right now, we show wind and rain combining to cause damage. So in say it's a construction site and a hurricane blows through and there's high velocity winds and heavy rains. Equipment and scaffolding on the site gets damaged. It's damaged because it's knocked over by the wind. It's damaged because it's water damage from the rain. Each of those causes independently of the other would have caused damage, but combined together is what happened to create the damage you're dealing with. How do you say which portion of the damage was attributable to what cost?
So what's the answer? What's the answer?
Well, the answer is the courts have started to develop what we call the concurrent causation doctrine, which specifically deals with these types of scenarios where the efficient proximate cause doctrine is just impossible to apply. And under the concurrent causation doctrine, the general rule is that where the loss or damage occurs as a result of two causes, one of which is covered and one of which is not, the coverage is provided. So the coverage exists where an insured risk constitute concurrent cause of the loss, even when it's not the prime or efficient cause, as opposed to the efficient proximate cause doctrine.
Okay, so let's just stay there for a second. So that rule, at least, and that's not the only rule, I think, right? But for that rule, this is good for policyholders. If it turns out in your example that's up here on the screen, that let's say that the rain is covered, but the wind is not, it doesn't really matter if they combine together under that rule, because since at least one of the things is covered, every part of the damage is covered. Is that right?
That's correct. So this is the minority view, but there are several jurisdictions that will follow this approach. And the courts will not. Just to throw out there, do you have a handy which states are following that rule? Yes, Florida, Kentucky, Minnesota, North Carolina, Pennsylvania, Wisconsin, and Texas with an asterisk. And let me explain why. Texas has a modified version of this rule, which is actually not policyholder friendly at all. It's the exact opposite. And under the Texas modified rule, yes, there may be coverage where the two causes combine to create the loss, one of which is covered, one of which is not, but the insured bears the burden of proof to segregate the damages and show to the jury what portion of the damage was caused by the covered peril versus the excluded peril. So the coverage only exists for that portion of the damage caused by the covered peril, and this can be a really heavy burden for the insured to meet in trial.
Yeah, obviously we've got to deal with the case law that exists in Texas, but it strikes me that there should be an argument even in Texas that the burden of proof should not necessarily be fully on the policyholder. We haven't talked about this, but these types of policies are what we call all risk policies, meaning essentially there is coverage under these policies. You don't have to prove a specified peril. There's coverage as an all risk policy to begin with, and the burden almost right off the bat shifts over to the insurance company to have to prove the exclusion. It would seem that if Texas wanted to follow the theory of their own rule, when we're talking about what part is excluded, when there's an all risk policy, then at least under those circumstances, the insurance company should have that burden of trying to prove the impossible, which is how do you separate these things that really can't be separated. But that's for a fight for another day to try and change what that precedent is in Texas. But is Texas the only one who seems to put that burden on the policyholder for this combined causation issue?
Yes, for those jurisdictions following the concurrent causation doctrine, they are the only jurisdiction as of now to create this burden on the insured. And in practice, it's just there's factual scenarios in which the insured could just never meet this burden. Yeah. Again, the example where neither cause on its own causes any damage, but combined they cause the damage. How do you attribute a portion of the damages to either?
Yeah, and I note your list of Florida, Minnesota, North Carolina, Pennsylvania, Texas, and Wisconsin. It's pretty important that for hurricane purposes, that Florida and North Carolina are in this pro-policyholder minority rule. If you can get the law of those states to apply to your loss, we're going to be in better shape. But let's flip over to the other rule. Explain what the other rule is that doesn't follow this idea that if one of them is covered, that everything is covered.
The other rule,
I think you refer to as this one's the minority rule. What is the majority rule?
The majority rule, oh, thank you. The majority rule is the efficient proximate cause doctrine is applied to these non-sequential losses as well. So in the majority of jurisdictions, the courts will try to make the efficient proximate cause doctrine work with causes of loss that are simultaneous. Sometimes they can do it, sometimes they can't, but really by definition, simultaneous losses means you cannot determine where in the chain of events the dominant cause occurred.
Well, so you've been a commercial litigator for all of your career, and we try cases to juries all the time. Is this, again, this efficient proximate cause, is this something that ultimately the jury has to decide after hearing all the facts about what damage was caused and what preceded, what activity occurred before then that might be the efficient proximate cause, and ultimately the jury has to come up with a conclusion as to what is the proximate cause of the loss?
That's correct. And then it would be up to the judge to determine whether or not that cause is excluded or covered under the policy.
I know that we've talked about this a lot. We always favor jury trials because juries tend to be much more sympathetic to the policyholder and do try to find coverage where it's owed under the circumstances. So this seems to be, at least compared to some other problems we run into with insurance coverage, where it ends up being an interpretation of the policy that the insurance company wrote. We often like the fight that happens in front of the jury on issues of fact as opposed to policy interpretation. So at least we can say that even the majority rule, which is not as good for us as the rule that says everything's covered if there's one part of it, it's still a pretty good rule for policyholders to be able to try to prove that the cause of the loss is a covered cause in the first instance.
Yes, the good thing under both doctrines is that even though there is an excluded cause of loss that contributed to the damage, you're not necessarily out of luck. There is still coverage to be had, and the burden of proof is on the insured to show, depending on the doctrine, that it's either the dominant cause or it is or to show the segregated damages under the Texas modified rule. But one thing to be wary of is that insurers have caught on to this, and they're now attempting to contract around the efficient proximate cause and concurrent causation doctrines. And what they're doing is they're including anti-concurrent causation clauses in their policies, which basically say that where a loss is caused by a combination of excluded and covered perils, the entire loss is excluded from the coverage. And the burden of proof is on the insurance company at trial to show that the anti-concurrent causation clause excludes the coverage entirely. But the majority view is that most jurisdictions, most courts will enforce an anti-concurrent causation clause as long as it's unambiguous. There are, however, a few jurisdictions which have disallowed them as contrary to public policy or statute, and those are Connecticut, North Dakota, Washington, and West Virginia. Everywhere else, an anti-concurrent causation clause, if properly drafted, could negate your coverage.
Yeah, I think you said Connecticut, you meant California, right?
Excuse me, yes, thank you, California.
Okay, so California, what, North Dakota, Washington State, and West Virginia actually say, despite the fact that the policy says has these anti-concurrent clauses in them, they won't enforce that. So that's good for the policyholder that they actually can go back to either the efficient proximate cause doctrine, or they can possibly have the majority rule. It's worth noting that when it's a public policy type of decision like this, either by statute or case law, it often means, and I don't want to get too technical here, but we talked about choice of law a few minutes ago. Even let's say you were in a California court, and that court was called upon to make a decision because let's say the owner of the property is in California, but the property itself is in Florida. Interestingly enough, the way it would work, that even though Florida law might enforce the anti-concurrent clause, but California has a public policy against it, when a California court actually uses Florida law, public policy will prohibit it from using that part of Florida law that violates California public policy. So you'll get the benefit of Florida law with the benefit of the fact that the anti-concurrent causation clause will not be applied because of California public policy. So there's a lot of things that go on here. And again, this goes back to the fact the reason we were forced to be a national practice from our inception is that we have this interplay of different states' law, and what court you're in can affect even another state's law like this, where there's a public policy against the enforcement of the anti-concurrent causation clauses. So just staying with these clauses a minute, I've noticed that that a good portion of policies actually have them. You need to look through your policy to see if you have one, but they don't necessarily apply to every single exclusion. Have you seen that as well? That it's not every exclusion that can have that anti-concurrent. And so that some of the things that you've mentioned as being the ones we're going to bump into may or may not be affected by the anti-concurrent causation clause.
That's correct. The location of the anti-concurrent causation clause in the policy is going to control whether or not it applies to the exclusions in the policy. So if it's in the preamble to all the exclusions, then it likely applies to all, but if it's embedded somewhere within the exclusions, then it would only apply to those particular excluded losses.
So Kelly, with the example on the screen, do you want to kind of walk us through something maybe more specific? Should I move to the next slide here?
Yeah, let's go to the next slide. We have an example that we've been sort of talking about a little bit already, which is the wind-driven rain combines with a defectively installed window to cause a loss. So in this example, the combination of events that are independently insufficient to cause the damage on its own, but both events are required for the damages to occur. So if you could go to the next slide, we have another diagram here, which shows where we have the covered peril, wind-driven rain, the excluded peril, defectively installed window, and the damage to drywall in the middle. So the question becomes then, is the damage to the drywall covered? And we have to look at the policy, and we also have to look at the jurisdiction that we're in. So if we're in a jurisdiction that applies the concurrent causation doctrine under the general rule, then the answer would be yes, all of the damage to the drywall is covered. If we were in Texas with the modified concurrent causation doctrine rule, then the answer would be yes, but only that portion of the damage caused by the wind-driven rain is covered. And the burden is on the insured to establish that amount of damages, which, as we've discussed, is almost impossible to do.
Yeah, I mean, of course, we try to argue, especially if we were able to get to the jury on it, that you know, you had a defectively installed window. It was dry the day before. It was dry the day before that. Until the hurricane came along with this wind-driven rain, we didn't have a problem. And so that the real cause is the wind-driven rain. Now, that may or may not fly in Texas as to sufficient to prove that the damage was potentially exclusively due to the wind-driven rain, which is kind of a problem.
Exactly. And then there's also the majority of jurisdictions which would actually try to apply the efficient proximate cause doctrine to this loss scenario, which really doesn't work because it's unclear. The burden is on the insured to show wind-driven rain is the dominant cause. And how can you show that when they've happened simultaneously? It's hard to say because one without the other wouldn't have caused the damage.
Yeah, although I feel pretty good about that one as the policyholder for this particular example, it's pretty hard for me to feel like that we had dry weather and my defectively installed window, if it had sat there for a month, would have caused a problem. It is only due to the wind-driven rain combining with it, and therefore the real proximate cause is not the defectively installed window, because that alone certainly didn't contribute to the situation. It's almost like saying, well, what caused the situation is you had a building in a hurricane area. Therefore, the real cause is you building a building there. Well, I think that there's a philosophical problem with cause and effect. There always is. But a jury having to decide what the efficient proximate cause, I think they're probably likely to say, that's why you bought a policy, to cover the idea that when wind-driven rain happens under this and causes you damage, it's going to be covered. And I think they're probably likely to lean toward the policyholder if the facts we can put on in front of that jury are going to support it. Do you agree with that, or you think that's probably a little bit wishful thinking?
Well, I do agree with that, but I know that insurance companies are going to argue that without the defectively installed window, nothing would have gotten wet. So, you know, it's the chicken and the egg, and you have to, you know, basically grapple with how can we show one of these is dominant and one of these is not, and you really don't know until you get to trial and you put on your case with the jury.
So then we always have, like you said before, the overlay of the potential ACC or the anti-concurrent clause. So how would that play out here?
Correct. So in addition to understanding what jurisdiction you're going to be in, you also need to know your policy language. So if you do have anti-concurrent causation language, you got to find out what it applies to. Does it apply to all excluded losses or only some? And then in majority of jurisdictions, if that clause is unambiguous, the entire loss would be excluded. And of course, there's the 4 states that say that's against public policy, and they would essentially strike the anti-concurrent causation language from the policy.
All right, that's a good example. Do you want to do one more for us? We can go to the next one.
Yes, we've got one more here, which in our example, if you go to the next slide.
Yeah, I'm just having a little technical difficulty. Let me get there. There we go.
There we go.
Oh, it went too far. Try it again.
There we go.
All right. Yeah.
So in this example, we have windstorm and rain, which causes falling water intrusion. So in this example, during a hurricane, as we see all the time, a roof's shingles get blown off and water starts coming in through the roof. So that would be the covered loss. And then we have the excluded loss, which is the storm surge flood that is caused from the storm, and that's the rising water intrusion. So we've got water coming from the ceiling and water coming from the ground. Go to the next slide. We have another Venn diagram here showing the covered peril and the excluded peril combining together to cause damage to the flooring. So this is a great example of when the combination of events is each separately responsible for damage on its own, but isolating the damage attributable to each cause is essentially impossible, right? Because we've got water coming from both places. And of course the flooring's ruined, but who's to say it's more ruined from the flood than it is from the falling water? So we would, again, want to go through the policy, understand the policy language, and also know which jurisdiction we're going to be dealing with. And if we're in a jurisdiction that applies the pro-policyholder rule, the concurrent causation doctrine general rule, then yes, all the damage to the flooring would be covered. But if we're in Texas under the modified rule, the answer is still yes, it could be covered, but the burden's on the insured to show what portion of that damage was caused by the windstorm and rain versus the storm surge and flood. And again, it's basically impossible to do. Under the efficient proximate cause doctrine, the answer is once again unclear. How could the burden's on the insured to show that the windstorm and rain is the dominant cause, but who's to say when the water is coming from every angle and the entire floor is ruined?
That actually, both those examples very helpful. I think you did a great job going through this, and I think we're kind of at the end of the program. Maybe let's look at the takeaways for this program, and we'll close out with that. Up one too far. Here we go. So walk us through what you think are the takeaways for us, Kelly.
So the takeaways for today is when you're faced with a hurricane-related loss, you want to analyze your policy before determining the relevant facts. Understand the coverage that is available and the coverage that is excluded. Evaluate the facts based on that coverage provided by your policy. You want to critically analyze all the causes of loss and carefully assess which state's laws will apply. Then, taking all of that, you want to do what we call package the claim. Package the claim in a way to maximize your coverage. Maximizing coverage is making sure if you're in efficient proximate cause jurisdiction, that your dominant cause that you're emphasizing in your proof of loss is one that is covered by the policy.
So let's just stay with that last thing, this packaging the claim. It kind of is common to all the programs we do and the work that we do. I guarantee you an insurance company never writes you a letter about whether you have coverage without knowing exactly every part of that policy. The problem is that policyholders, especially if they haven't contacted lawyers, and particularly if they haven't got a lawyer who actually does insurance coverage work on a daily basis, they aren't familiar with the policy the same way the insurance coverage is. It's not a level playing field, and they're tending to write emails to people and write letters to the insurance company that are talking about things that if they understood the language they were using was talking specifically about exclusion, they would have been a little bit more careful, that they would have been more accurate about the things that really mattered to the coverage. I like to give the example, I've given it often, in programs that have heard me talk about this movie that I love. It's called Anatomy of a Murder with Jimmy Stewart. It's an old movie from the 60s. And Jimmy Stewart is assigned to be the defense counsel for someone accused of murdering, it's either his wife's lover or her rapist, and it's unclear which it is at the outset. But the opening comment that Jimmy Stewart, the lawyer, makes to the client is, before you tell me what happened, I want to explain to you about the insanity defense. Now tell me what happened. Now, there is a much more specific discussion of what occurred at the time with those ideas in mind. The insurance company does that every day. They write to you and talk about what happened, always with the idea in mind about how it is they're not going to pay your claim. To put it on a level playing field, you need to read that policy. You need to analyze what's going on. You need to decide what your claim is going to look like. And every letter that you write and every time you talk to the insurance company, it needs to talk about it in a way that maximizes your coverage. And that's what we're here to help do. And you did a great job today, Kelly. I really enjoyed doing this program with you. And
thank you. It was my pleasure.
And so let me just go to the last slide, which just says thank you to everybody for listening. And you can reach any of us if you want to at any time. So thank you.
Thank you.